I do think I'm legally obligated to share that these photographs of Josh and I are pre-COVID photographs. Since that time, we have become a little more shaggy and each put on about 15 pounds. So we're relieved that what you're seeing now are the slides and not a current video feed. But let me share with you what we'll be going over in the presentation today. We're going to begin with some context and framework so that you can understand the significance of this new rule in the context of what you already know about Title IX. The second part of the presentation, which I will also be covering, is a description of what remains included within the purview of Title IX and what will now, because of the new rule, fall outside of Title IX. You're all going to need to become very familiar with how to make that demarcation and identify a complaint that comes in as still belonging to Title IX or now being pushed outside the scope of Title IX. And we'll do some work with you in terms of teaching you how to do that. For the cases that remain Title IX, then, Josh is going to talk about the new procedural requirements, and we'll also talk about how to handle the cases that are no longer Title IX. Last but not least, we want to help give you some prioritization as you prepare for these regulations going live, so to speak, on August 14th, 2020. As Josh mentioned, the Department of Education released these late last week. They have said that they must be implemented as of August 14th of this year. Obviously, they are aware of the extraordinary circumstances that all of you are operating in, but they have not seen fit to delay the implementation of these rules, and we expect enforcement, frankly, to be very aggressive. So we know that that is a short time frame, and we know that you're working under extenuating circumstances, and we want to give you some initial guidance of how to start implementing these changes. Okay, so with that, let's begin as we always do, with just locating ourselves in time and space and reminding ourselves that Title IX is a law that has been in place for many years, and that the intention of it is that American students not be excluded from participation in or in other ways burdened because of their sex, that we want education to be an area of equal opportunity for people of all genders. And so this slide graphically demonstrates how we have a female student in this case. Now, as you know, Title IX applies both to male and female students, but traditionally female students have been more burdened by gender discrimination. And so you see here this dark bar of gender discrimination between this student and her educational goals. And we know that gender discrimination can take many forms. It can be an outright prohibition on a particular gender, taking certain majors or being allowed to participate in certain activities, unequal funding of athletics. Pregnancy discrimination is another form of discrimination that Title IX has sought to overcome. And of course, the reason that we're here today, the broad category of misconduct that falls under the term sexual harassment. The Department of Education is currently using the term sexual harassment as a catch-all term for all of those terrible and problematic behaviors. So when you hear the term sexual harassment in this presentation or otherwise, it doesn't just mean the kind of verbal harassment that we often speak of, but also physical sexual assault, stalking, and domestic and dating violence. So how does the law address all of those things? They weren't all addressed in the original law. Well, the answer is through rules and guidance, and they're listed here on your screen sort of in the order of their weight, or in the order in which they impose responsibilities on schools. So obviously the law, Title IX, is the highest level of authority. It's mandatory. The next level are agency rules, so rules issued by the Department of Education after those rules have gone through a formal process to be issued, and those rules also are mandatory. And then the third category we have, which is the weakest category, is agency guidance. Agencies don't have to go through such a thorough process to issue guidance. They can do it much more in their own discretion. And arguably, guidance is not mandatory, but most of us are very careful not to run afoul of it anyway, because you don't want OCR on your campus doing an investigation and fining and imposing other problems and then have to go to court to try to overturn those. So even guidance carries a heavy weight of authority, although it's the weakest of the three. So to put those three categories into the context of Title IX itself, the law, the Obama-era Dear Colleague letter and all of the guidance that came out of the Obama administration starting in 2011 was all guidance. So although it created a tremendous change in terms of the way that colleges and universities all across the country handled sexual harassment, it was in fact the weakest level of federal authority. What we have now from the Trump administration is a formal rule. It is something that has gone through a formal process, now cannot easily be changed, even if in the fall a president from a different party were to be elected. So this rule is here to stay for the foreseeable future, and it is mandatory. So as you are speaking to folks in your own campuses who are confused about the back and the forth, and do we really have to follow this, and I thought we were going in a different direction, this is a big change. It is a rule, and that rule carries significant authority. So what were the Trump administration's overarching goals in putting this rule into place, which they have really frankly been working on for almost 4 years now? Well, the first goal was to narrow the scope of incidents that fall within the law. The view of this administration is that Title IX under the Obama administration, it touched too many things. It cast too wide a net. And so to illustrate that graphically, just a moment, Dr. White, I'm having some trouble advancing the slide here. Let's see if we can get
Okay, it just moved. If we could get everybody to also remember to mute your phones as well, your microphones.
So here we have Title IX, symbolized under the Obama era, and now under the Trump era final rule, what you will see is that the jurisdiction of Title IX has shrunk in a significant way. The second goal of the Trump administration was to recalibrate the balance between the rights of complainants, who we could also describe as victims or survivors, and the right of respondents, people who have been accused of sexual harassment or misconduct. Now, in the view of the Trump administration, the previous guidance about Title IX gave too many rights to complainants and burdened the rights of respondents, was not fair enough to those accused of sexual harassment. So you may agree with that or you may disagree with that, but that is the perspective of the current administration. So you will see in almost everything that Josh and I talk about today that one of these two goals is being served by every rule change. So to tackle this first one, this is just another graphic way to think about it. Under the previous guidance from the Obama administration, we had a very expansive view of Title IX and what it could cover. And when something was on the bubble or you weren't sure, it was usually a good guess to go with, yes, it's covered by Title IX and we better handle it, right? Now we're going to be operating under a system of rules that is much more selective, where the door is not wide open to every possible complaint, but where that opening has really narrowed. Some cases are going to come through, some cases are going to be shut out. And the first way that we see that narrowing of the door is And what triggers a school's responsibility to respond to something? Well, as many of you know, and could lecture on yourselves, under the prior guidance, almost everyone at a school was considered a responsible employee. Anyone that a student might reasonably perceive to have authority or responsibility to report, and so that cast a very wide net. Also under the previous guidance, as you know, schools were responsible not just for the sexual misconduct that they actually knew about, but for things that they reasonably should have known about if they were paying close attention. So there was a heavy burden on schools to respond to incidents that were reported, really, frankly, almost to any employee on campus, and close attention, because you would be held responsible not just for things you knew about, but things you ought to have. This is an area where we now see a change. The whole perception of responsible employee, that is gone. What we now have is that schools must respond to sexual harassment when a report is made to an official with authority to institute corrective measures. Well, who is that? The Department of Education's answer is that that is whomever the school designates. Schools have wide latitude to decide who are these officials. It can be narrower than the definition that you used for responsible employee. This is an area, as Josh indicated, where we may see more guidance in the future. For example, our operating assumption is that coaches and professors, in addition to administrators, are officials with authority to institute corrective measures. And so they likely should fall within your definition. But that is not 100% clear at this time. The most important thing right now going forward is that you clearly designate who these officials are, who you consider to be the people on your campus who have authority to institute corrective measures, and that needs to be published so that everybody else knows it too. So if you have invested a lot of time and energy in other resources in making folks on campus aware that they need to report any concerns, knowledge, suspicions of sexual harassment that they may have, and you've spent the last 4 or 5 years drilling that into their heads, often with our help, you don't need to go out and change that. Folks on your campus can remain, quote unquote, mandatory reporters to you. That will not make them officials under this new definition. But I would not go out there and try to roll back and tell people they don't need to report things anymore. That is a healthy system. Keep that in place, but have a new conversation about who the real officials with authority are. And moving forward, you will be held responsible for what those people are made aware of, not what everyone may be aware of. And then, of course, the second part, the Trump administration has also taken away that reasonably should have known about. Now you will only be legally responsible for the sexual harassment that you actually know about. And so that is the first significant narrowing. Okay? Those of you who are Title IX coordinators or perhaps supervised Title IX coordinators and have ultimate authority for this are going to have to become very familiar with what I've described here as 3.5 threshold questions to determine whether a case is a Title IX case under this new rule. So what are these critical questions? Well, the first one is, who is the complainant? And by complainant, we mean victim. Okay, not necessarily the person who brought the information to you, not the person who's reporting it necessarily, but the person who was allegedly subject to the sexual harassment. And this is the little half question, 1.5. Was the complainant in the United States when the conduct occurred, when the bad thing happened, was the complainant in the United States. I'm not aware of any of your colleges having study abroad programs. They may. The rules are really changing with respect to those. The complainant has to have been in the United States for it to be a Title IX issue. Moving forward, where did the incident take place? Incident or incidents. And we mean that geographically, but we also mean the context. Was it in the context of a school program? And then last but not least, what type of conduct occurred? The Trump administration has narrowed the type of conduct that falls within Title IX. And so what we're going to do now is go through each of these questions in greater depth. So the first one, who is the complainant? So again, anyone can report sexual misconduct, and the new rule makes that plain. Sexual misconduct reports may come from many sources. The person bringing it forward does not have to be the person who was victimized by it. But regardless, we call the complainant the person who allegedly survived the conduct. Even if they never complained, they are still the complainant. And the new rule says for a case to go active within Title IX, when the complaint is filed, that complainant has to be either participating in your programs and activities or trying to participate in them. Okay, they have to have a currently existing relationship with the school. So what about visitors? Well, probably not, unless they're part of a program. If they're just visiting a friend on your campus, no. What about graduates? No. So if someone has recently graduated and then they turn around and want to file a complaint about something they experienced last semester while they were still a student, they are not now currently participating in one of your educational programs. So this would be outside of Title IX. The same thing, students who have dropped out or who have transferred to other programs, anyone who is not sort of currently participating, actively enrolled in one of your programs, cannot be a complainant for a formal Title IX investigation. Well, God Almighty, you might be saying, think about these terrible gymnastics cases that have happened and how the athletes, some of them reported after they had graduated. Are you telling us we have to ignore a report from a recent graduate, even involving a student or employee who remains on campus? That would be crazy. And of course, good news, you don't have to ignore it. The Title IX coordinator may initiate a grievance process, him or herself, if they believe that it's required under the circumstances. The Title IX coordinator can do that whether the complainant doesn't qualify because they're not there anymore, or if the complainant is still at school but just doesn't want to file a complaint, but you look at the situation and you say, this is something we need to investigate, other people may be at risk. Okay, so this is actually, in the end, very similar to what we had before, right? The door is narrower in terms of who can come in, but you as the Title IX coordinator can sort of push it open again if you think that that's necessary. And really, as before, if you're going to proceed with a formal case, even though the complainant, the victim, doesn't want you to do that very thoughtfully. Don't do that in an automatic, knee-jerk, well, we just always do that sort of way. Really consider, is this necessary to protect others or to serve important policy grounds? Okay, so now we're going to move on to the second question, which is, and this is again, of course, only if you get through the who, right? Either the complainant qualifies Or if they don't, the Title IX coordinator has decided this is important enough to push this forward even without a qualifying complainant. Okay? Now we move to our second question. Where does Title IX apply? Well, in the past, of course, you knew that it applied on campus, and it also applied in all your programs and activities, even if they were not on campus. So, for example, a clinical internship in a local hospital or something like that. But under the Obama administration guidance, it really didn't matter where the conduct occurred. If two students went to Cancun for spring break and something very terrible happened down there and one sexually assaulted the other, and then they came back and had to sit next to each other in chemistry class, well, that impacted the educational environment. And so even though you had no control over what happened down there in Cancun, you still had to handle the case as a Title IX matter when those students came back, right? That was the old way. This is what it looks like now. Under the new final rule, schools are responsible for handling Title IX matters that happen in their programs and activities and likely on their property as well, including and this doesn't apply to many community colleges, but including even fraternity and sorority houses if property is owned by a student organization that's officially recognized by the school. So you can see that a huge area has just been taken away from the geography here. All of a sudden, anything that happens off campus, assuming it's not in a program somehow, is no longer Title IX. This is a huge change. So here we have, again, explaining the question you have to ask is, do we as the school have substantial control over the context here? Does it fall under our umbrella? Anything that's your education programs or activities does, so classrooms, your campus grounds, and facilities. If you have a hotel on your campus, as I know at least one school in the system does, your sporting events, regardless of where they take place, your sporting practices, your extracurricular activities, your clinics and internships, if it is something that you are running, then incidents that happen within it can be Title IX. Well, what does that exclude? What does not fall under your umbrella? Everything else. If it happens in a house or an apartment that you don't own, if it happens in a bar or a restaurant that's not yours, if it happens at a party, I mean, it's the universe, right? It's the whole universe of places that students and employees interact outside of your programming. If an incident happens outside of your programming, it is not Title IX. It is something, and we will address that. But you can see now there is a tremendous distinction between a sexual assault that occurs on campus or in the context of a program, even if it's not on campus, and a sexual assault that occurs somewhere else. In the past, you know, as long as those things happened between enrolled students, it was sort of the same. It didn't matter where it happened. Now it matters very much. Okay, and our last one is actually the most complex, and this is what constitutes sexual harassment. Everyone remembers the bucket, right? It's not red on this slide, it's black, but we have a big red bucket of terrible things that people can do to one another: sexual assault and stalking and domestic violence and verbal sexual harassment and demands for sexual favors. And we got pretty good at recognizing what went into that bucket and what didn't. Well, now we have to recalibrate that a little bit. So let's do that now. Sexual assault is in the bucket. That's everything from vaginal or anal rape to someone, you know, grabbing someone else's buttocks when they walk by. Unwanted sexual contact that's physical. Dating and domestic violence, still in the bucket. Stalking, a course of conduct that repeated incidents that causes someone to feel fearful. And from now on, we're going to have standard definitions for this. So for better or worse, I think actually probably for better, schools aren't going to have to come up with their own definitions of these things or crib them from someone else. We're going to all be on the same page with definitions that come out of the Clery Act, the Violence Against Women Act. Okay, these things are still in the bucket. Another thing that is in the bucket is a school employee, and that could be a student employee as well, saying, I will give you this or that if you do something sexual for me. Lawyers call this a quid pro quo, this for that. And in a famous example of a school that I worked with, there was a professor who would call students into his office and say, you've got a C or a D right now, but if you unbutton your blouse and let me see your breasts, I think it could be a B plus, right? That is a classic quid pro quo. Do something sexual for me, and I will do something, give you something back that you need. That is in the bucket. Last but not least, we still have a category for verbal or expressive sexual harassment that is unwelcome, but the definition of this has changed. It is not as broad as it was before, and so we're going to look at this a little bit more closely. What constitutes sexual harassment? Well, the definition I just put up here was from the Obama administration. It was unwelcome conduct of a sexual nature. And they gave some sort of general categories here, but this cast a hugely wide net. If it was conduct of a sexual nature and the recipient considered it unwelcome, it was in the bucket, right? Anything from an unwelcome request to go out on a date to a lewd remark, a dirty joke, everything was in the bucket. There was a lot of debate over how that definition should potentially be narrowed, and the Trump administration went with an aggressively narrowed definition. And the key words are there highlighted in red. It's still unwelcome conduct, but it has to be so severe, so pervasive, and so objectively offensive that it effectively denies a person access to education. So it's not just that it was unwelcome, it has to be severe and pervasive, meaning widespread or repeated, and it's also measured in terms of the impact that it has. So let's look at some specific examples, because this is a tremendous change. A lot of conduct that used to go into that red bucket is kept out by this heightened definition. So let's look at an example. Cat calls on the way to class last Thursday, right? You're walking to class, there's someone who likes to sit there on a bench in front of the building and make remarks about your body as you go by. Well, there's some argument about this, of course, and I suppose it's, exactly what they say, but probably not severe, or if it just happened last Thursday, not pervasive, right? If it just happened one time last week. So that does not go into that darker ring in the center there. It's on the outside, not in the bucket. Okay, well, let's think of something that is truly severe. Surely we can do that. Well, let's go the other way. Let's make it pervasive, right? Let's say it happens every day. So now someone's sitting on that bench outside of your sciences building, and they're making remarks about your body every day when you go in. Now it is pervasive. But are we at severe? Not necessarily. Again, it depends on what they say, but if it's, hey baby, looking good, I like the way you move in that skirt, probably not. Let's think of something truly severe. How about a threat of rape? That's pretty severe, right? That was the most severe thing that I could think of when putting together this slide. That's terrible, but if it happens once, it probably doesn't meet the standard because it's not pervasive. it's only severe. And the definition is clear that these things are stacked. It has to be severe and pervasive. All right, well, logically, let's go forward here then. What if the threats of rape are daily, but you persist through it and you keep going to class and you keep doing well and you don't let it stop you from getting your education? Even that may be outside this new definition. So this is an area where I want to say this is still being sorted out. We don't know exactly how everything will be interpreted, but I give these examples to illustrate how narrow this new definition of sexual harassment is, right? What's something that would fall inside it? Well, how about daily threats of rape that result in a student dropping out of school? Okay, now we have severe, pervasive, and effectively denied access, right? But a very narrow definition. If conduct is verbal or expressive rather than physical, and it's not a quid pro quo from an employee, they have made this high and tight. And the reason is that the Department of Education has given is free speech concerns. So they tried to carve out some things that, like stalking, like domestic violence, and like the quid pro quos, carve some things out. But then when they were left with what is verbal and expressive, it is hard to meet that new definition. Okay, so what happens if the answer to who or where or what doesn't qualify for Title IX? And I see a great question from Michael Hughes over in the comment party. He says, okay, do we start, where do we go with this? Well, that's what we're going to tell you next, right? So if the case does not qualify based on the who, the where, or the what, it must be dismissed. The school must dismiss the formal complaint with regard to that conduct that doesn't qualify. Now, it's entirely possible that you might have a complaint describing multiple incidents, and some qualify and some don't. So a complaint can be dismissed in part, but the part that doesn't meet the standard must be dismissed, right? I'm going to just take a quick little detour here to say that there's also such a thing as a voluntary dismissal under these three circumstances, and that's where the Title IX coordinator exercises discretion to dismiss the case, again, under the three circumstances listed here. But if it doesn't qualify as who, what, or where, it's not discretionary. It's a mandatory dismissal. Okay? If a mandatory or a voluntary dismissal occurs, you as a Title IX coordinator have a responsibility to notify both parties in writing and to provide the reasons that the case or a part of the case was dismissed, and there is a right to appeal that. Okay, so you may say to someone, I'm sorry, I'm dismissing the part of your case that happened uptown on High Street because that wasn't in one of our programs or activities. It wasn't on our campus. And they might appeal that and say, well, the whole class was going out to lunch, so I think actually it was an educational program, right? So there'll have to be an appeals process for that. And presumably the party that would be appealing there would be the complainant. Okay? So let's go through a little pop quiz to make sure that we're all on the same page with mandatory dismissal here. A student complains that one of your public safety employees makes suggestive remarks to him whenever he sees him, about once a week. Again, some of these things, it's going to all depend on a judgment call based on the facts and circumstances, but probably mandatory dismissal. Probably not severe and pervasive, and there's no suggestion here that it's a quid pro quo. A student complains that a professor told her, girls don't belong in this class, but I sure do like to watch you coming and going. Wow, that's not appropriate. But if it only happened once, not pervasive, looks like another mandatory dismissal. A student complains she was sexually assaulted by 2 older students in the restroom of a local bar. Now we have the what is covered, right? We know sexual assault counts, but this doesn't look like it happened in an educational program or activity that you're running. Hold on a second, I've got it there. There we go, another mandatory dismissal. And last but not least, a student complains that an ex-girlfriend, who's also a student, has been following him home every time he leaves campus and sitting outside his house in her car for hours. Sounds like stalking to me, right? And we know that that's covered, but it's not taking place on campus or in the context of an activity. So again, we have a mandatory dismissal. Wow. If you're paying attention right now, your mind has been blown and you're saying, you are kidding me. We can't do anything about those incidents? Those incidents are now take place with impunity, including even inappropriate things done by employees. We can't do anything about them. Yes, you can. Yes, you can. And here's why. Dismissal under Title IX does not preclude action under another provision of the school's code of conduct. This to me was the big reveal of the final rule. We have known for months that the administration was going to narrow the definition of Title IX and what fell within it. But the $10,000 question for me was, well, what happens to the other stuff? Will you be forbidden from pursuing it? Are you required to ignore it? What will you do? And they have made very, very clear in this new rule that you can pursue it. You just don't pursue it under Title IX. So this is one example of something that could happen, right, with the 4 incidents we just discussed. That Title IX door is closed, but the inappropriate behavior on the part of the employees, that can be referred right over to human resources to be handled in an appropriate way. What about the other stuff that students did that now is not Title IX? March that right over to student conduct and address it appropriately through your disciplinary processes and the rules that you have for students and student conduct. This wouldn't have to be the way you handle it, but that would be one possible way of handling it. What's another way? Well, if you don't have human resources policies that cover that sort of thing, or in the unlikely event you also don't have student conduct procedures that would cover that, another possibility is that those claims go to the claim graveyard and nothing happens if all the doors are shut. So one of your important tasks in the weeks ahead prior to August 14th is to figure out, if I am closing the Title IX door to a claim, what is the pathway for that claim to go forward? Do we want it to go to the claim graveyard, or is there another path for it to take through the institution, and what is that path? Because here's a quote from the Department of Education's own materials. A school may address sexual harassment. Now remember, when they use the term sexual harassment, it means all those forms of sexual misconduct, not just verbal, affecting its students or employees that falls outside Title IX's jurisdiction in any manner the school chooses, including providing supportive measures or pursuing discipline. In any manner the school chooses. Is everyone hearing those words? Wow, those are permissive words. So wait, are you telling me that the Department of Education will let us refer non-Title IX cases to other offices for investigation and discipline? Yes, I am. Are you telling me that the Department of Education will let us use the same procedures we will be using for Title IX cases to investigate and discipline non-Title IX cases? Yes. You could use the exact same procedures that you're going to use for the Title IX stuff on the other stuff. You got to dismiss it first, but you just say it's dismissed from Title IX. Now we're going to pursue it under our non-Title IX policy. Could we use our current Obama-era procedures to investigate and discipline non-Title IX cases? Yes. Could we use our old pre-Obama era procedures to investigate and discipline these cases with the way we did it the old way, where each student would just come in and tell their story to one administrator, and then the administrator would just decide and tell the students what the decision was? Yes. Gosh, could we run simultaneous parallel procedures for different aspects of the same course of conduct? So address the on-campus stuff that happened through Title IX and the off-campus stuff through a different way and run those at the same time, even though they were different processes with different outcomes? Yes. And last but not least, could we actually just ignore and do nothing about the non-Title IX cases? As far as DOE is concerned, yes. So this structure, I hope we're communicating adequately, gives tremendous freedom and leeway to each institution to decide in the context of your culture and values and existing rules how you want to handle cases. Literally every option is open to you. The Department of Education has really narrowed its focus, and for what falls into Title IX, they're going to be very demanding about how you handle that. And Josh is going to talk to you about what those procedures are going to be. But for all the stuff that falls out of Title IX now, which as we've seen is a lot, you've got some big decisions to make. And so this is a slide that sort of shows that jurisdictional analysis that you are going to do. These little tiny blue explosions here, those are cases marching into your door, and you are going to run who, where, and what on each one of those. Some of them may be obvious when they march in the door. Others you may have to do some investigation to determine who is the complainant, where did this take place, what is the conduct. But then you're going to be making a determination. Yes, this is Title IX, or no, it's not Title IX. Okay, so if is Title IX, you're going to keep it. And you're going to run it through the procedures that Josh is going to outline. If it's not Title IX, you could send it elsewhere, or, sort of crazy but true, you could keep that too and run it in exactly the same way. It wouldn't be officially Title IX anymore, but if what is efficient for your institution is to still have the Title IX coordinator have responsibility and authority over those cases, you can stick with that. It can still all run out of the Title IX office. And so now we've gotten to the point where we say, okay, you have a Title IX case, now what? So we're going to stop talking about those cases that fall outside of the Title IX orbit, where you have the big decisions to make about how you're going to handle those. We're going to narrow our focus as well. We're going to talk about what remains. So sexual assault, domestic violence, stalking, if it occurs on your campus or in your program, quid pro quo from an employee to a student, show me your breast if you want a higher grade, that sort of thing, right? And then those, whatever qualifies still from verbal harassment, it's not much, but if it makes it into that inner ring, now you're looking at that much smaller universe, and Josh is going to take over from me and talk about the new rules, the new procedures for handling those. Josh?
I'm here and just switching over so that I can control the slides. Thanks so much for that, Sarah. That's just such a phenomenal content there and a really great and interesting breakdown of complex subject matter, as we all just saw. This is the honest truth. Every time Sara and I collaborate on a presentation, I go after, I kick myself when she starts talking and say to myself, I have to go first next time, because she's a tough act to follow. But thank you for that, Sara. That was a great breakdown. And as Sara mentioned, we're going to shift gears now to the third and fourth parts of the presentation and talk about that kind of now much more narrow side of the house, which is, what do you do when you have something that does fall within Title IX, that checks all the boxes that Sara laid out in great detail, that hasn't been dismissed for any reason? How are you required to handle that? What are you required to do to meet minimum standards at least? And what we're really talking about here, let me just put this to you conceptually. What we're really talking about here is, how are we going to have to adjust, revise, flesh out, change our existing Title IX sexual harassment policies and procedures, right? We've been doing it one way under the previous approach. Maybe we've had a single investigator model. Maybe we've had a model where we have some type of investigation that hands off to other adjudicators. What will we do now? So I would challenge you all, as we work through this, kind of think in 3D. Don't just take in what is the new requirement, but think about how it relates to what you've been doing on campus and what it might take to kind of start to adjust to that and bridge that gap in your policies and procedures. So when we have something that falls within Title IX, the overarching standard, and I would say kind of the baseline standard that the Department of Education is going to look to if they're required to come in and see if you're compliant, is deliberate indifference. And so the idea is that if you have something that qualifies as Title IX, the school, to discharge its obligations that have now been triggered, cannot act with deliberate indifference, which means that the school cannot respond in a way that is clearly unreasonable in light of the known circumstances. And I'll say, although there are stringent requirements about the procedures, if you're a school that has compliant procedures that you're applying here, that deliberate indifference standard gives a pretty significant amount of leeway within the procedures, to make decisions about responsibility, supportive measures, and other things we'll talk about. But that's the standard that we're aiming for. Coincidentally, that's also the standard, or maybe not coincidentally, but that is also the standard that courts look to if you have a lawsuit from a complainant who says, this school didn't either ignore it or didn't react appropriately to my complaint. So there's some synergy there between the courts and Department of Education. How are we going to get there? How are we in our Title IX offices going to make sure that we're not deliberately indifferent? What does that entail? Well, there are really three possible paths to this: supportive measures, informal resolution, and a formal grievance process, which is much more formal than ever, as we'll talk about. And so let's talk about each of those in turn. Supportive measures, which, to be totally clear, you can offer to a student whether there's a formal complaint or not, and should offer to a student whether there's a formal complaint or not. Supportive measures are things that help the complainant stay in school. We'll talk about this in more depth, but that don't discipline the respondent. So these are somewhat like, to draw an analogy, somewhat like some of the interim measures we've been putting in place, but these are not necessarily interim. These can be long-term as necessary. We'll talk more about supportive measures. Informal resolution is another way that you can go here. Informal resolution refers to mediation, restorative justice, and those types of efforts where you try to work out the situation between the parties without a formal grievance procedure, but doing something more than just supportive measures. There are many limitations around that. We'll talk about those limitations as well. And finally, you could go the route of discharging your obligations by following a formal grievance process that could end up in discipline against the respondent. And we'll talk about the enhanced requirements around that. An important concept here at the bottom of this slide, which is that the decision of which path to take is driven primarily by the complainant. And so that's another, I think we could say, kind of overarching goal of this administration's effort here, is to put much of this in the hands of the complainant in terms of how they would like to proceed. So, for example, a Title IX coordinator is not going to implement supportive measures without having talked with the complainant and gotten the complainant's input about those measures. Not totally bound by what the complainant says, but that is critically important input. Likewise, you're not going to proceed with informal resolution unless that's something that the complainant and ultimately the responder are on board with. And the grievance process, again, requires, except for limited circumstances where the Title IX coordinator can use his or her discretion, requires a willing complainant, a complainant that's willing to move forward to a hearing. Let's talk in a little more depth. And what that does really is that tees up a very important initial kind of intake process and conversation between the Title IX coordinator and the complainant, because there are decisions to be made and options to be discussed kind of right away and supportive measures to be offered. So the Title IX coordinator must promptly contact the complainant, talk about supportive measures, get the complainant's input, talk with the complainant about the possibility of informal resolution and how that looks, and then ultimately explain the process for filing a formal complaint and talk through those options with the complainant. And then ultimately come to a decision point with the complainant. How would you, now that you understand the options, how would you like to proceed? You know, how can we best help here now that we're kind of in this Title IX space? Again, not that is the end-all, say-all, because the Title IX coordinator does have some discretion, but it gets very heavy weight how the complainant would like to proceed. And not totally different than what many of us have been doing likely before on this front. But more formalized around that initial discussion with the complainant. So let's dig deeper into kind of each of those three avenues and first talk about appropriate supportive measures. Again, the Title IX coordinator should offer those whether there's going to be a formal complaint or not. So if you're in the informal resolution realm, you should still be thinking about supportive measures. If you're in the formal grievance process, think about supportive measures, and you may only offer supportive measures. I'll always have these in mind. Make sure that they are things that ensure educational access, protect student safety, and deter sexual harassment. So those might be things like some kind of no contact order, you know, the changing of class schedules, maybe a safe walk, you know, some of the things that we've been doing before to try to keep people safe and comfortable on campus. But these supportive measures are not disciplinary, and that's a line that can't be crossed with regard to the supportive measures. Remember, to impose discipline in the Title IX context, on the Title IX side of the house, we're going to have to go through a prescriptive formal grievance process. So we can't come over to the supportive measures side of these options and impose anything like discipline there. They can't punish anyone, can't serve as a disciplinary context or consequence, and can't unreasonably burden the other party. So if you get a request, you know, move this person out of my class so that I can be in the class, that might be something that you can't do, right? That's going to be something that you're going to have to think through very carefully. The limitations around supportive measures, note the caveat there at the bottom, do not completely foreclose the opportunity to implement an emergency removal and or administrative leave of a student and or administrative leave of an employee under certain limited circumstances. And those are laid out in the regulations. And again, that's a decision the Title IX coordinator will make and that will need to be addressed fully in the processes and procedures. So again, I'm going back to my challenge in case we've lost track of it. Already we're thinking about the fact that we have to, in our policies and procedures, you know, kind of build out and flesh out some things that maybe we didn't address as fully before. Supportive measures and how we get to those supportive measures. Now, the possibility of informal resolution has new limitations and kind of options as well. So again, when we talk about informal resolution, we're talking about mediation, restorative justice, and things of that nature. Something that, you know, is an effort to address the situation, the conflict, but to do so short of a formal grievance process that would end in discipline on the Title IX side of the house. May only offer informal resolution when a formal complaint is filed. So without a formal complaint, this isn't even in the picture as an option. Really, without a formal complaint on the Title IX side of the house, we're probably looking then at supportive measures only, right? But if we have a formal complaint, we can have a fork in the road to say, okay, do we want to move forward with this grievance process, or might this be something that's appropriate for mediation, for informal resolution? Not something that schools can require of either of the parties. It can be presented as an option in these limited circumstances. If it's going to move forward, there has to be voluntary written consent from the parties after they've received a new detailed notice about informal resolution, how it works, its limitations. Informal resolution is not allowed for employee on student harassment. And really, this last bullet I think is important. We do see this as an opportunity to bridge a gap here. You know, again, far less things will be going through formal grievance processes under Title IX. Sara talked about some of the ways that we might address that, you know, through other disciplinary processes, through supportive measures. Informal resolution provides another opportunity to take action, to take appropriate action, but not within a formal process. But it requires significant thoughtfulness and training. I mean, think about this with me for a minute. If we're really going to have one of our folks, you know, sit down and try to run a mediation between two parties who, where we're talking about behavior of a serious enough level that it's made it kind of into this Title IX realm, then we're going to have to really arm them to do that well. And there's going to have to be, you know, significant training around that, significant thoughtfulness around the limitations. So again, thinking back to how we're changing grievance processes and procedures, this will be addressed more fully going forward, but also our practices and our training around this have to evolve if it's going to be a real option. And here's kind of the aspect of this that has gotten, you know, the most attention, that got a lot of comments. It is the formalization of the grievance process. So we've made it into Title IX realm. We've stayed there. We're, for whatever reason, it's not going to be only supportive measures. It's not going to be informal resolution. We are going to move forward with a formal grievance process. How is that different than before? It still involves an investigation. It still involves an adjudication, but they look much different now. The requirements look much different now. So let's start out with this graphic, which I think lays this out well. And again, let's think 3D here about where we've been on these issues and where we're being asked to go. And really, this dovetails back with the point that Sara made earlier, which is that an overarching goal of this administration is to build in more protections for respondents. I think some of these things benefit complainants as well. Some arguably don't, but this is an effort to formalize the process so that respondents, you know, have more protection in the process. So you start with adequate notice. Think about the fact that, you know, at some point over the past 5-6 years, we've probably all on your campuses at some point weren't even providing much notice to a respondent, right, before you sat down with them for an interview, or if you were, it was maybe relatively informal and short. That has shifted over the past couple years, and now is very much formalized and requires much more, and I'll go into detail about that. Think about the right to review evidence of not just the respondent, but both parties. Think about where we've been. You know, I mean, I have not worked with many community colleges and many institutions at all that have been sharing all evidence gathered essentially with the parties before finalizing the report, and then sharing the report with the parties and providing some opportunity to submit additional information around that. Some schools have moved in that direction, but think about how much more robust that is and how much more onerous, arguably, than what you all have been doing. That's where we're headed. And then finally, on the opportunity to be heard, I know of a lot of community colleges and, again, other schools that have not had any hearing at all up until now. The ones who have been likely to have somewhat of an informal hearing, kind of an administrative panel or something like that. I think live cross-examination at a hearing and the requirement for a live hearing has been extremely rare, and that's where we're headed here. So that gives kind of an overview. And last but not least, many of you, I think, based on the community colleges I've worked with, many of you do have an appeal of some sort and typically provide that to both parties. I think as of now, that's absolutely required going forward. You have to provide an appeal to both parties, so not optional. So let's talk about this written notice, and frankly, not much of this has changed from, you know, those of you who I or Sara have done training with in the past 2-3 years. We've been talking about these notices and making sure that folks are using them. So you see the requirements here. I won't run through every single one of them. I will point out that the third one of those, I think, is, although some folks might have been including it before, is new in terms of an absolute requirement. The statement that a respondent is presumed not responsible, and I apologize for a typo there, that a responsibility determination regarding responsibility is made only after a grievance process is what that should say. In these notices, we'll want to provide information about advisors of choice, and I'll say more about what that looks like at the hearing level. The ability to review evidence, we're going to go ahead and signal to the parties that you will have the chance to review this evidence before the report goes final. And then finally, we'll want to, in that notice, mention key dates and keep them updated on key dates throughout the process. Interviews, the hearing, deadline for submission of information, those types of things. And finally, and we've talked with a lot of you about this as we've gone as well, there's a duties to supplement as this evolves. If you find new types of allegations that might be in play, then you have to update this notice. The point being that we really don't want to get to the end of an investigation or resolution and for anyone to be able to say, I didn't know that was a potential allegation or a potential violation. It wasn't in a notice. We want everyone to be on the same page about that. I'm looking at the time and realizing that I'm going to have to speed up a significant amount. So I'm going to fly through a few of these slides because I really want to get to the part where we talk about what you all should do next, and you all will have these slides. So bear with me as I run through a couple of these relatively quickly, and we leave a little bit of time for questions. The investigation, there's no other way to state it except that investigators are going to have to do a much more kind of formalized and robust effort now. The single investigator adjudicator model is out the window. The investigators have to be someone different than the decision maker, and that has to be someone different than the appeal authority. Investigators still need annual training. Nothing has changed there. What has changed is that the contents of that training have to be published on your website per the regulations. They still need to be impartial, and we still need to watch out for conflicts of interest. Those are things that we've been doing. Just kind of skimming through here. Certainly the parties will still need an equal opportunity to present evidence, and there are no gag orders going forward. And what I mean by that is we can't say to the parties, don't talk with anyone about this, because that could curtail their ability to gather and provide evidence. Again, thinking in 3D, these are all things that are going to have to be spelled out in these new policies and procedures. And then the last bullet there is important. Again, prior to the completion of the investigative report, we'll be sending to both parties the evidence that we've gathered in the investigation, and giving them 10 days to weigh in on anything that we might have missed. And I think, this is onerous, for lack of a better term, but I think there's protection for investigators built in here too, is to make sure that that after the fact, no one is saying you missed something really important. You're getting a chance to do that as you go. The report ultimately absolutely will have to go to the parties. No discretion around that anymore. I think that will be a significant change for many of your institutions. And it will have to go to the parties at least 10 days prior to a hearing or other determination of responsibility. I'm going to jump forward to the hearings because there are important things to touch on there. Live hearing, which may be accomplished virtually, is absolutely required to record or have a transcript of the hearing. Talked about the fact that you have to have at least one kind of independent and separate decision maker there. And this is a place where a school has to provide an advisor of choice if a party shows up without one. Not an attorney, not the advisor of the student's choice or I'm sorry, the party's choice, or someone necessarily aligned with the party, but you have to have someone available that you can provide at no cost to the party to kind of help them navigate the hearing at least. Cross-examination, this is one of the I would say most controversial aspects of the new regs. Regulations, one of the most impactful changes, in that this has to be allowed at the live hearing. It's not cross-examination by the parties of each other, but by their advisors, by an advisor of the other party. Has to be done direct and in real time. The decision maker at the hearing is going to have to play kind of a gatekeeper function around those questions. And so think about how this role of the decision maker at the hearing is kind of multiplying and getting more formal and frankly more difficult as well. We'll have to make those decisions in real time and be trained to do so. If a question is totally irrelevant, the decision maker will exclude it. There are limitations on the types of evidence that can come in and the types of questions that can be asked. The decision maker or hearing officer will have to be ready for that. And if a party refuses to submit to cross-examination, then all their statements in the investigation are disqualified and can't be used in making the determination. So this administration is not not messing around, so to speak, with regard to cross-examination. They're very serious about it being an absolute requirement here. Zooming through some more important points here. The standard of evidence. Before, at one point, the preponderance of the evidence was mandatory. Now there's an option to go either preponderance or clear and convincing. That's going to be, some of the things we've talked about are absolutely mandatory, right? You have to have, for example, cross-examination. There are some things that are going to take some significant thought on your campuses about how you want to approach this as an institution. Do you want to be a preponderance of the evidence? Do you want to be clear and convincing instead, a tougher to meet standard? And the important thing is that once you decide that, it has to be consistent across complaints against employees, faculty, students, and really all sexual harassment complaints. And then ultimately, another place that we'll have to formalize our processes is around the determination of responsibility. No more kind of short 1 or 2 paragraph notifications. We determined that you were not responsible because the evidence said so. Not that anyone's doing still that anymore. We've expanded beyond that. Maybe we were at that place at some point, but now I won't run through all these in the interest of time, but you see here on the screen multiple things that have to go into this determination of responsibility. I'll pause there to say, and I'll say it again later when I get to the suggestions, one of the things you all are going to want to do on this front, in addition to revising policies and procedures, is to come up with a set of forms and kind of template party communications, a form report, a form determination of responsibility, so that you're not having to kind of reinvent this wheel every time, and you can be consistent around it, because they are long and detailed and prescriptive requirements. I have another slide of them here. The determination of responsibility will have to lay out the appeal rights. And again, we mentioned before that you have to allow both parties an appeal on at least these limited bases. You can expand the appeal rights to other bases if you would like. Have to have a different decision maker, and you will not be shocked to hear that there are also prescriptive requirements about how the appeal runs and how parties submit evidence in connection with the appeal and how that's reviewed. Those are things also that will have to be fleshed out in more detail in the new policies and procedures. So I zoomed through that important content to leave at least a little bit of time for our suggested next steps, because we have thrown a lot at you. I assume some folks are feeling overwhelmed. We empathize with that. We are working through this. We're all in this together. And so where do we go next with this? Where do you all go next with this? These are not all the next steps, but these are things that if I were sitting in your shoes on campuses, if we would jump into right away. And I'll run through these quick too in the interest of time, but I'll hit them all. First, I would sound the alarm. I would, if you're the ones that have been sent out here kind of by the institution to learn about these important changes, go back and say, this is absolutely serious. This is law now that carries all the weight of law. And we fully expect that this administration is going to be, I would say very aggressive in their enforcement. I think they signaled that with the August 14 compliance date, pandemic notwithstanding. They've signaled that with some of their comments since then. And, this is an administration that, and this is a hot button issue for both parties going into a campaign season. And this administration has, at times, through tweet or otherwise, called out higher education and called out specific institutions. So not to be a fearmonger by any stretch, but to say this needs the urgency that it deserves. This is not an optional lift. It's not an easy lift. This is something that we all have to jump on right away and get ready for August. It's likely going to require either internal resources or an increase in budget to look to external resources. I wish it weren't that way. It's not a good time for it to be that way, but that's the case. This is not even, think about what you did on campuses in terms of effort and resources and spend around trying to comply with Obama era guidance, right? Probably 60 pages in all of guidance. And now we're looking at 2,000 pages of binding regs, right? Impactful. So think about what that entails in terms of a ramp up. Moving through these, we strongly suggest that you quickly develop a core team and assign ownership to this. The core team should at least include the Title IX coordinator, but certainly not only the Title IX coordinator. I wouldn't make this team everyone who is an investigator, an adjudicator, and you have 20 cooks in the kitchen, so to speak. You get 3 or 4 core people who are going to own this together and really work through this over the next couple months and assign ownership to someone for all the obvious reasons that we do that to make sure that this gets handled. Systematically tap into available and free resources and analysis. We're doing this webinar, every day I get some invitation from another law firm that's doing a webinar or putting out an alert. Many of you all have connections with many law firms and trade organizations. We've done this internally. I would on your campuses assign someone to be kind of the guru of all, I call it cribbing, the guru of all kind of gathering together helpful resources. Because we're probably multiple of you on your campuses are going to have to actually read the regs, actually do the deep dive, but give yourself every advantage you can as you do that. There's a lot of content out there right now. Got about 13 minutes, and these are all very important points. So, and on Q&A, we're going to end up short on time for Q&A, but we will gather those questions and work with Dr. White to circle back with you all on them. Think about the need for external resources and move quickly. And I want to be delicate around this because I know that resources are limited. I know that budgets are more limited than ever. So please I don't say this without having that in mind, but most schools are probably going to, I think, many schools are going to determine, it's up to each school, but many schools are going to determine that this is a heavy and complex enough effort that they're going to need a law firm or some other, outside entity to assist with it. I will tell you, as one of those law firms, it's getting busy really quickly. And we're certainly not the only ones who do this. There are a bunch of folks available to you all, I think, throughout the state and beyond who do good work in this area, and you can reach out to any of them. But they have a lot of schools reaching out right now to say, please help us with everything we need on this front. So if you're going to do that and reach out to a firm or someone else, I would suggest jumping on it right away. I think a lot of firms will be filled up within the next few weeks, so to speak. I think this is a great time to consider standardization, pooling, outsourcing, and working groups. There are arguments on all sides of standardization across a system like the UNC system or the community college system. There are good reasons to do it, good reasons not to do it. We don't want to overstep. It's not ultimately our decision. But in this particular context, there is merit to considering on your campuses as a system what it would look like to have some standardization across your policies and procedures and how that might build in efficiencies around training and pooling of resources and those types of things. You all deal with a lot of the same issues. You deal with a lot of the same unique issues like early college and commuters and things like that. Think about how that would help you all. And it may be possible to do it as a system. It may be possible to do it kind of in groups. But if you have the same policy and procedure to a large extent as some other institution, there's the possibility of maybe sharing some of these more onerous roles, these investigator roles, these decision maker roles, or sharing kind of access maybe to an outside person or group of persons that you might bring in as necessary. So working groups around kind of core issues that affect all community colleges would be great as well as you kind of sort through, especially the discretionary decisions. Are we going to have half community colleges with preponderance of evidence, half clear and convincing, a third who address things not in Title IX through other conduct processes, and a third who don't, and a third who do sometimes and don't. I think you get what I'm saying with that. So think hard about that. We will be talking with Dr. White and some other folks about options for individual schools and for the pooling and kind of standardization approach over the next couple weeks. And again, I say we are not the only ones available on that front. We love doing this work, but other folks do it as well and do it well. So think about which way you want to go if you're going to go outside. A couple quick last things here. Once you've done all of that, once you've kind of gotten the attention and buy-in from folks to give you the resources and kind of leeway and support and team you need to do this heavy lift, once you've thought about external resources and pooling and standardization and those things, that's all building toward kind of the epicenter of this, I think, which is you've got to dig into that, your policy and procedure and revision and really start to work through that. Again, August 14th compliance date. Most policies and procedures that I know of are going to need a pretty significant overhaul. So that's the next big piece of this. And along with that, again, we would strongly suggest developing form documents and templates. That's another place where partnering with another school or another bunch of schools or some level of partnering could be really useful and helpful. And finally, we would suggest targeting a scheduling of training on the new policies and procedures for probably late July, early August, notwithstanding the fact that, if we have sexual harassment complaints in the meantime, we certainly have to deal with them. We all have limited resources. We don't see a lot of utility in doing a training like right away on not fully formed revised procedures or on old procedures. We think angle toward having those things in place by late July, early August, and have a training kind of right away in advance of or very close to the compliance date. That is all we have. Thank you for bearing with me as I really ran through that last bit. I hope it made some sense and was helpful. And Dr. White, Sarah, John, I guess we do have 8 minutes left.
Josh, I've been tracking some of the questions here, and I'm happy to start tackling a few of those, if Dr. White and Dr. Evans, if that's okay with you.
That would be fine, Sarah. I'm gonna slide the screen up just a little bit and start with Michael Hughes' question. If you can see it, can you see it, where he talks about regarding only if they are a currently enrolled student? And I think that question has to do with your presentation, Sarah. He says many of our schools will still consider someone a student, though not currently enrolled, because they were enrolled during the previous semester.
Yeah, that's a good and detailed question that we will have to probably get back to on, in terms of, if a student is not currently participating, where do they fall in that? There was a related question that Michael and Wendy Dodson were raising, which is, in discussing the verbal sexual harassment, I said, it may not be bad enough unless it functionally forces you to drop out. And then they said, but hey, if you drop out, now you can't complain anymore. How can you explain that? Well, I can explain that. I think, pretty clearly there is a strong push from the Department of Education to limit verbal sexual harassment cases to vanishingly rare circumstances. However, again, just to emphasize, what they've taken away with one hand, they've given back with the other hand, in terms of providing freedom to schools to address quote-unquote non-Title IX issues in whatever way the school thinks is appropriate. So don't worry too much about that bind where you say, well, gosh, this is creating a system where it would be impossible for a student to ever complain about verbal sexual harassment, because you can create a procedure that is appropriate and that is in keeping with your rules and your culture that addresses that. I'd also like to address Michael Coleman's question about, he had a question, I think, about an off-campus rape that I said would be excluded. And he said, well, what if the rape causes so much distress that the student drops out of school? And of course, we can all envision a situation like that. The reality is that when it comes to sexual assault or domestic violence or stalking, we don't evaluate it for severity or pervasiveness or impact on the victim. We only go through that analysis when it's verbal or expressive sexual harassment. Rape, domestic violence, and stalking are all automatically included, but only if, again, they take place in the context of your program or activity or property. So the reality is that for example, a rape, no matter how grievous and no matter how great the impact, if it was outside your program or activity, outside your grounds, it is not Title IX. Again, that does not preclude you in any way from addressing it fully as the school believes to be appropriate. You just won't be addressing it as a Title IX matter. You'll be addressing it as a different type of disciplinary matter. And Jamie McGuire made a good point that if it's, something that's not Title IX, it may still definitely be criminal, and a student may want to pursue, a student or employee may want to pursue criminal remedies as well as whatever the school provides from a disciplinary point of view. I also wanted to address another question, I think, from GTCC about, if a case comes in and we're not sure initially if it's Title IX or not, should we follow Title IX procedures just in case? And the answer to that is yes. You want to stay on that safe Title IX ground until you make that determination. Well, what does that mean? One thing it means is don't discipline the respondent right away. Some schools had sort of these procedures where like a student athlete would be benched or, something like that if an allegation were made. Well, if it turns out to be a Title IX matter, that would be a significant violation of the rules. You have to have a process prior to any disciplinary action, unless it's an extreme safety situation where you have to do an emergency removal. So to be safe, don't discipline the respondent right away. Do offer supportive measures right away. Do provide notices and proceed as if it is a Title IX case until you determine from the answer to who, what, where, that it's not. And then at that point, provide the written notice of the dismissal and explain how that decision can be appealed.
Okay, Sarah, did you see Jasmine Spain's response underneath Jamie McGuire, where he says that it may not be allowed for employee on student harassment, but what about student on employee harassment?
I did, but I wasn't sure what, can you either help me understand the context of what that question is about, or?
Okay, Jamie, can you unmute your phone? Jasmine, can you unmute your phone and ask that question? Clarify your question. Okay, he's not responding, so he may have left. So that might be something that I'll reach out to him and find out from him a little bit later. I'm going to scroll down to see if there's some others. Okay, you answered some of these questions you've already answered. Can the student select an advisor that is not a member of the college community? And you said yes. Do you want to expound on that? Is that a normal process? Or
yeah, I can do that. I can just say, I can answer it quickly by saying that the school cannot put any limitation whatsoever on who is the person, but the school can limit that person's participation. Certainly the caveat for there's going to be that cross-examination down the road, but you can still limit participation by the person, but certainly can't limit it to the school community.
Okay. Okay, so.
And in fact, there's a new requirement that you need to not just inform students that they are entitled to select an advisor of their choice, but you need to explicitly inform them that they may select an attorney, which of course is likely going to result in more attorneys participating in the process, which is not ideal from the perspective of colleges and universities, but it's clearly the direction that the Department of Education wanted to push this in, is for respondents to have more legal rights and protections.
Okay. And also, Josh, there was a question about you and your team providing training and support to specific colleges that can afford to move forward with that kind of assistance. And Sarah has provided your contact information, but do you want to expound on that?
Yeah, I will. Thanks for the question. We are scheduling calls with a number of schools that want to talk about individual support for the week of May the 25th. And I would say if you're interested in having that conversation, which we would love to do, just reach out to me and we can schedule the time. And I see an email from a person or two since we started, one with a voicemail that I apparently missed a couple days ago. So I apologize for that, but we'll be quick to get back with you and schedule along those lines. Also, we'll be finalizing kind of options for pooled possibilities, and we'll be back in touch on that.
Okay, thank you.
We think that, just 20 more seconds on that, we think that the best way to do this is to engage with the school and really do an individualized kind of customized approach within a set of options because of what it requires here.
Okay. Sarah, did you see the question from Manuel Dudley about Title IX pregnancy accommodation changes? Are they the same, or whether there's anything new with Title IX accommodations for pregnant ladies?
No, we both believe that is the same. The real focus of the Department of Education here is on sexual misconduct, narrowing the scope, and providing more procedural protections for respondents. So other things that historically fall under Title IX have not gotten a revamp.
Okay. And it looks like there was a question about the Clery Act, if any changes were made to the Clery Act or modifications, and Sarah already responded to that. The big picture answer on Clery changes is no. So
Right.
I think that's great.
There is a question coming in from Chris Chafin here about respondents selecting attorneys and resource issues for colleges. This is a great question. He's saying, if we have to provide an advisor that may not be an attorney, and what if there's a possible disparity in representation? This is a very significant issue, and of course the disparity can go either way. You might have a respondent with a fancy attorney and a complainant with no one, or you might have a complainant with a fancy attorney and a respondent with no one. And either way, there are real social justice and equity issues, present. Some schools have actually dealt with this by providing attorneys at the school's expense to students who don't have them when another attorney is involved. Obviously, that is a real luxury of resources that many schools cannot afford. Another option is to have some people who are employees but who are sort of well qualified to play that role, and then to really invest in their training so that although they may not be attorneys, they are on a similar, well qualified to represent students and can hold their own with a different kind of attorney present. Again, that takes resources too, but maybe not as much. Both of these, issues go to the importance also of the hearing officer, the decision maker, having control over that hearing and being qualified enough and competent enough to constrain both advisors, whether they're attorneys or not, and to be able to rule on the spot on whether questions are appropriate or not, whether the advisor's behavior is appropriate or not. Those individuals are going to need significant training, and we think that the general trend, if this pushes in one direction or another, is going to push schools to outsource those hearings. Again, another resource issue, schools that can afford it to bring in attorneys or retired judges to run those hearings rather than putting that burden on, somebody who's a biology professor.
Okay.
I just want to add something real quick on a question that I got via email. When I talked about scheduling calls with individual schools for the week of May 25th, I've already got some emails on that. That call would be, just to be clear, totally no cost. That would just be us talking about what is available and what might work or not work for your institution.
Okay, thank you, Josh. There's a clarification to the question that Jasmine Spain asked. He says, what I'm asking is when I hear it may not be allowed for employee on student harassment, I perceive that as the employee is the respondent and the student is the complainant. So my question is it the same when the employee is the complainant and the student is the respondent?
I can jump in on that. I think I
Okay.
didn't catch that the first time, but I think that's referring to informal resolution and the fact that that's not available for the first instance you described, which is employee respondent, student complainant. As far as I know, that prohibition only goes one way technically, but I would say it's a really great question because as I think about it now, you may want to in your policy say, and again, there's discretion around informal resolution. It's never really required. You offer it as an option when you think it's appropriate, and if the parties want to do it, then that's how it goes. You could, as a school, decide we're not going to have informal resolution in any matters involving a student on one side and an employee on the other, right? You could say we just don't think that's a good imbalance of power to put together. But in terms of a flat out requirement, the requirement or the a prohibition, better said, a prohibition is only one way.
That's right. And Josh is right. The reason it's that way is that the perception is that if for example, a professor and a student are in a mediation, again, the student is the complainant, there may just be too much intimidation, that the power differential is too great for that informal resolution to be legitimate. Arguably, if it's the other way, the student has been harassing and the complainant is an employee, that employee may arguably feel comfortable enough. So the Department of Education has left it up to schools when it comes to that direction.
Okay. Okay, I think we're almost at the end of all of the questions. If we have anybody on the phone that needs to ask a question, you can do it now. And at the same time, I'm going to scroll the chat box to see if I see anything that I may have missed. Michael Hughes, are you still on the line? Did we answer your questions? I'm just going to scroll down to the chat box to see if he responds. He said he's good. He's good. So if there are no other questions, let me just thank you all for participating in this webinar. Josh and Sarah, thank you so much. The information that you provided was just very, very valuable. And I am aware, as far as I know, your contact information is on the presentation. And so I'll be sending that out to everyone after we end this call. So they should receive it this afternoon. If you need any additional information from Josh or Sarah, please feel free to contact them. You can also contact the system office. If you just email me and need to get in contact with them, I'll forward your information to them as well. I will also be sending out the recording. I have one of my staff members online, so he's going to walk me through the process of getting this recording to you. So if you don't have it this afternoon, you would definitely have it by Monday morning. So again, thank you, everybody. Thank you, Sarah and Josh. And I'll be looking forward to speaking with you very soon after the meeting, Josh.
Right,
And
I will
Sarah,
call you. Thank you all. Thanks, Dr. White.
Okay, you all have a great weekend.
You as well.
Thank you, Dr. White.
Okay, bye-bye. And John, let me ask the question. John, are you still on the line before we hang up? John Evans, Dr. Evans, are you still on the line? Okay, all right. Okay. Yeah, everybody can hang up now if you like. I'm just going to hold on for a few more minutes to connect with one of my staff members.